And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
Imagine a game of high-stakes legal poker. A state puts its entire Second Amendment power on the table, essentially daring the federal government to move against it. The federal government calls their bluff. But then, under a new administration, the Department of Justice winks and whispers to the Supreme Court, "We'll narrow the sweeping injunction against this state law if you just look the other way and deny emergency review." The Supreme Court took the deal. They looked the other way. And the promise? That deal evaporated the moment the Supreme Court issued its denial. That's the core. Brutal truth of the Missouri SAPA case, the Second Amendment Preservation Act, where an 8-1 emergency denial just fundamentally changed the landscape of the state sovereignty fight forever. The constitutional battle here wasn't just about firearms. It was about political maneuvering, judicial trust, and what happens when the executive branch makes a concession to the highest court in the land, only to immediately renege on the agreement. We are talking about a critical case that was seeking Supreme Court emergency review, dealing directly with whether a state can dictate terms of non-cooperation with federal gun enforcement. The Supreme Court, in a recent order list, officially denied that emergency review to the Missouri SAPA case. But the denial itself is less important than the reason behind it, and the political fallout that immediately followed. Let's look at the backdrop. Turiarn, the power of non-enforcement. Missouri's aggressive SAPA. The lawsuit revolves around the 2021 Second Amendment Preservation Act passed in the state of Missouri. This was not a passive law. This was a direct, pointed counterpunch to federal enforcement efforts. Missouri's legislature did two things that put this law in the crosshairs of the Department of Justice. First, the law set the state's official interpretation of the Second Amendment, labeling certain federal laws and regulations as infringing upon constitutional rights. That's standard state posturing. Second, and this is the crucial part, the law imposed massive restrictions on the support, funding, and cooperation that the state would provide to federal agencies, attempting to enforce those laws. It explicitly prohibited Missouri officers, agents, and government officials from helping federal agents who were attempting to enforce laws the state deemed unconstitutional. But the most radical part, the provision that truly made this law unique, was the creation of a civil remedy. Under the SAPA, any resident of the state of Missouri could sue a Missouri official if that official helped to enforce federal laws that violated the Second Amendment. This shifted the power dynamic entirely. It armed the citizenry with a specific legal tool to enforce the state's non-cooperation policy. Missouri essentially devolved the true enforcement power of its sovereignty defense to its residents, not its state agents. This was designed to be a poison pill for federal collaboration. It was crafted to be an aggressive application of the anti-commandeering doctrine. Anti-commandeering and the judicial trap. For those unfamiliar with the doctrine, anti-commandeering is a pillar of federalism derived from cases like New York versus United States and Prince versus United States. It establishes that the federal government cannot force state governments or state officials to administer or enforce federal regulatory programs. The state can say no. Missouri's argument was straightforward. If we have the constitutional right to say no, we also have the right to put up internal mechanisms, like prohibitions on state officers and civil lawsuits, to ensure our no is effective. The Biden administration, when they initially brought the lawsuit against Missouri, argued that SAPA was invalid in its entirety because it was effectively nullifying federal law, which is constitutionally forbidden. They succeeded in the district court. That court decided to strike down the Missouri Preservation Act in its entirety, issuing a total, sweeping injunction against the law. Missouri appealed up to the Eighth Circuit, begging for a temporary stay on that total injunction while the case proceeded. They were denied. That led to the first emergency Supreme Court intervention request. When the Supreme Court reviewed the request for a stay, they issued an 8-1 order denying it. Only Justice Thomas was in favor of allowing the SAPA law, or at least aspects of it, to go into effect while the courts battled out the merits. The case was then sent back to the Eighth Circuit for a full review. The Eighth Circuit ultimately ruled in favor of the federal government, striking down the SAPA law entirely once again. But pay attention to the logic the Eighth Circuit used. This is where the legal theory takes a dark turn. Missouri pointed out in their subsequent plea to the Supreme Court that the Eighth Circuit essentially said the structure and potential operation of the SAPA law, the non-cooperation part, was potentially valid under anti-commandeering principles. But they struck it down because they disliked the underlying Second Amendment purpose. And most bizarrely, because they found that the SAPA law turned non-action into actionable enforcement. Wait, let's look at that again. The Eighth Circuit found that by complying with the state law, meaning by not helping the feds, A state official was still technically playing a role in enforcement, just in reverse. They found that compliance and non-action was still enforcement in action. This is judicial gymnastics of the highest, most dangerous order. If mere compliance with a state law is interpreted as enforcement against the federal government, it completely neuters the anti-commandeering doctrine. How can a state lawfully withdraw its resources if the withdrawal itself is deemed a hostile act, subject to federal injunction? It's a judicial trap designed to force state cooperation. Missouri had to go back to the Supreme Court. They had no other option. The deal and the betrayal. Now, this is where the political reality and the judicial process collide head-on. When Missouri sought emergency review the second time, the administration in control had shifted. The Biden administration's DOJ had initiated the suit, but the Trump administration's DOJ took over the defense of the injunction at the Supreme Court level. Initially, the Trump DOJ stalled. They delayed the case for months, keeping the Supreme Court in suspense. When they finally responded, they continued to argue that the SAPA law was invalid in most of its applications, and that the lower courts had gotten the decision largely correct. I know what you're thinking, but hear me out. At the same time they were arguing against the state law, they offered the Supreme Court a concession, a lifeline. The Trump administration argued that if the Supreme Court denied this emergency review request, if they kicked the case back down to the lower courts, the federal government would voluntarily decide to dismiss some of that total, sweeping injunction that was won by the prior administration. Why do this? Because the DOJ saw the flaw in the lower court ruling. They publicly stated to the Supreme Court, having reevaluated this case, the United States has concerns about whether the judgment below extends too far and enjoins applications of the Act that do constitute mere non-enforcement of federal law protected under the anti-commandeering doctrine. They admitted the injunction was too broad. They worried that the courts were actively enjoining simple non-cooperation, which is a violation of the federalism principles they supposedly support. The DOJ then stated explicitly that, given these concerns, the United States had decided that it would acquiesce in narrowing the scope of the judgment when the district court regains jurisdiction over this case. The state of Missouri's lawyers warned the Supreme Court that this concession was exactly why they should grant review. Missouri argued that the court shouldn't trust the DOJ to stay true to its word once the heat of the Supreme Court was off. They argued that if the court really believed the injunction was too broad, they should fix it themselves immediately. But unfortunately, the Supreme Court took the administration's word. The court chose the path of least resistance. Flirting. The 8-1, denial, and the silence. In the recent order list, the Supreme Court denied review. They chose to believe the executive branch when it promised to narrow the scope of the injury upon remand. This denial was the ultimate test of political trust. The denial essentially left the door open for the federal government to remove the overly broad, total injunction that had been issued against the Missouri SAPA. The court banked on that promise. This is the point where the case moves from dry legal theory to sheer political cynicism. Because to this point, months after the Supreme Court denied review and the case was officially returned to the lower courts, the Trump Department of Justice still has not moved for the district court to remove or narrow the complete injunction. The promise was made. The Supreme Court acted on the promise, using it as the primary justification for avoiding the messy business of a Second Amendment anti-commandeering challenge. And then, nothing. Silence. The total injunction, the ruling that struck down the entire SAPA law and blocked Missouri from exercising its sovereignty, remains fully in effect. If you're finding this analysis helpful, please take a second to like this video and subscribe to Law Advisor. It helps us keep these deep dives coming. Now back to the case. Judiciarians, what does this mean for the future? The fact that the Supreme Court was comfortable denying review based on a procedural promise that was immediately broken speaks volumes about judicial deference to the executive branch. It implies that the court, even the conservative majority, was willing to prioritize political expediency over the clear constitutional questions raised by the Eighth Circuit's bizarre ruling on non-action as enforcement. For Missouri, the fight continues, but the state has lost valuable time and leverage. While the case will eventually move toward a final judgment on the merits, the total preliminary injunction stands, freezing the SAPA law in amber. For other states considering aggressive SAPA legislation, the message is clear. The anti-commandeering doctrine is a shield, but if you try to turn it into a sword by creating civil remedies designed to punish state officials for cooperation, the federal government will attack you, and the Supreme Court may not intervene until the political dust settles. This case was supposed to be the landmark test of how far a state can go to shield its citizens from federal regulation under the guise of the Second Amendment. Instead, it became a dramatic lesson in how executive branch promises can be used to delay, obfuscate, and ultimately deflate a high-profile constitutional showdown. The integrity of the process was undermined, and the state's sovereign immunity remains hobbled by an injunction that the federal government itself admitted was likely too broad. As we get more information, as the standoff develops further in the lower court, Law Advisor will let you know exactly what the next move is. We are watching closely to see if the DOJ is eventually forced to make good on the assurance they gave to the nation's highest court. Thanks for watching, and don't forget to like and subscribe for more legal breakdowns. And remember, stay safe, stay smart, and never forget, knowledge is the ultimate defense. I'll see you in the next one.